Buenas noches, good evening, thanks for coming, gracias por venir. Mi nombre es Antonio Acevedo, my name is Antonio Acevedo. I work for the Arlington County Office of Human Rights. I am a staff from the Commission. Yo trabajo para la Oficina de Derechos Humanos en Arlington y soy un miembro del equipo de trabajo de la Comisión de Derechos Humanos del Condado. I am going to first and foremost introduce members of the staff of the Office of Human Rights, and then I'll introduce the moderator, and he will take care of introducing the rest of the commissioners here. Right here in front, the front row, we have Gurjit Chima. She is the executive director of the office. She's getting her feet wet. She started last month. And literally, she's getting her feet wet in Arlington tonight. Next to her is Ana Maynard. She's one of our investigators. Ana Maynard, uno de los investigadores. And now, I'm going to introduce, back there, David Gonzalez from the EEOC. And is there anybody else? Sandra Perez. Sandra Perez is my lifeline, putting together all the food and contracting and making sure we don't overspend because we have to give a report to the EEOC who's helping us with the money here. Okay, Roland Watkins. He is a vice chair of the Human Rights Commission of the county, and he's also the chair of the EEO Standing Committee. He will be the moderator tonight. He will introduce the speakers. Speakers will have 20 minutes, and then we will open the floor for a Q&A session. Thank you very much. Thanks for coming. Gracias.
Thank you, Antonio. Good evening, everyone. Welcome to the annual public event hosted by the Arlington County Human Rights Commission. As Antonio told you, my name is Roland Watkins, and I am the vice chair of the Arlington Human Rights Commission. This particular event is co-sponsored by the Arlington County Human Rights Commission and the United States Equal Employment Opportunity Commission. Thank you, United States Equal Employment Opportunity Commission, for being a co-sponsor and for the generous financial contribution which covered our refreshments this evening. Also, thank you to the Immigrant and Employee Rights Section of the Civil Rights Division of the United States Department of Justice and the Legal Aid Justice Center for participating in this event this evening. Now, in Arlington, it is unlawful to discriminate because of race, national origin, color, marital status, sex, religion, age, disability, and sexual orientation. It is unlawful to retaliate against any person who opposes discriminatory practices. It is unlawful to discriminate in the sale, rental, or financing of housing or commercial real estate, the provision of public accommodations, applications for an offer of credit, enrollment in educational institutions, private educational institutions, and employment. Now, the Human Rights Commission receives, investigates, and conciliates complaints from those who believe they have been victims of unlawful discrimination. Those complaints may be brought before the commission itself. So at this time, I want to acknowledge all of the members of the Arlington County Human Rights Commission who are here. So at this time, all of the members who are present, please stand. Okay. Thank you. The basic law for Arlington is the Arlington County Human Rights Ordinance, which is Chapter 31 of the Arlington County Code. Now, this statement of policy, which begins Chapter 31, is quite interesting. It starts out by stating that, quote, "It is in the public interest of the county to assure that each citizen is treated fairly, provided equal protection of the law, and equal opportunity to participate in the benefits, rights, and privileges of community life," end quote. It specifically talks about citizens. However, at the end of the statement is the following. This chapter is established to ensure the protection and enforcement of human and civil rights for all people living or working in Arlington by the elimination of and provision of remedies for discriminatory practices, end quote. I like the idea of ensuring human and civil rights for all people. As an individual with a little bit of legal training from an Ivy League law school, I interpret that all people as including immigrants and non-citizens. And in this regard, what are the rights of a non-citizen? This is what we want to discuss this evening. The purpose of this public outreach event tonight is to discuss national origin discrimination and how a non-citizen can seek enforcement of his right or her right. We want to inform and educate the community about the employment rights of non-citizens and immigrants in Arlington County. We will explain how a non-citizen or immigrant can file a complaint of discrimination, the investigation process, and the resolution of the case. And finally, familiarize the community with county and federal officials who are working locally in the field of human rights and employment discrimination. And in order to do this, we have a great panel this evening. What I'm going to do is to say a little bit about each panelist, and then we will turn it over to them. To my right is Sarah Daisley Digert. Sarah manages the outreach program for the Immigration and Employee Rights section, the Civil Rights Division, U.S. Department of Justice. It was formerly known, by the way, as the Office of the Special Counsel for Immigration and Employment Discrimination. Ms. Digert develops and implements outreach initiatives, she coordinates outreach events, and plays a critical role in the Office of the Special Counsel Information and Complaints Hotline program. She is bilingual and uses her language skills in English and Spanish in all aspects of her work. To her right is Mindy Weinstein. Now, Ms. Weinstein is the acting director of EEOC's Washington Field Office. She oversees operations of the Washington Field Office, including investigations, mediations, federal sector hearings, which is a big area, and community outreach and education. Before joining the EEOC's field office, Ms. Weinstein served as special assistant to EEOC's vice chair, Leslie Silberman. In this role, she provided legal and policy guidance to the vice chair on a wide range of matters and helped lead the EEOC's Systemic Task Force, which developed a new strategic approach to identifying and eliminating class-wide employment discrimination. And Ms. Weinstein previously held the position of regional attorney in the EEOC's office in Charlotte, North Carolina, where she oversees EEOC's litigation in North and South Carolina. Her prior experience also includes serving as an attorney in the EEOC's Systemic Litigation Program in Washington, D.C., served as special assistant to former EEOC Chair Evan Kemp, a trial attorney in the EEOC's Baltimore office, and a special assistant U.S. Attorney in Washington, D.C. She's a graduate of Wellesley College and George Washington University School of Law. To her right is Kristen Donovan. And Kristen Donovan represents the Legal Aid Justice Center. She joined the clinic in 2017 as an attorney, and I know I'm going to mess this up, Galilee Family Foundation, Public Interest Fellow. The Legal Aid Justice Center has been providing legal representation for low-income individuals in Virginia since 1967. Its mission is to seek equal justice for all by solving litigants' legal problems, strengthening the voices of low-income communities, and rooting out the inequities that keep people in poverty. Kristen Fellowship focuses on providing legal services to immigrant women in Northern Virginia's cleaning industry. Immigrant women dominate the residential and commercial cleaning workforce in Northern Virginia. They are acutely vulnerable to abuse by unscrupulous employers due to their precarious immigration status, economic need, and physical and cultural isolation. As a fellow at the center, Kristen helps immigrant cleaning women challenge unlawful employment practices and recover unpaid wages. She also assists workers facing discrimination and sexual harassment. She pursues complaints with the with the Equal Employment Opportunity Commission and with local human rights agencies, and she also litigates Title VII claims in federal court. Now, Kristen previously worked as an outreach paralegal with the Southern Poverty Law Center Immigrant Justice Program in Atlanta, Georgia, where she supported litigation on behalf of low-income immigrants in the South. She graduated from American University Washington School of Law as a public interest, public sector scholar in 2017. Now, at this time, each panelist will have about 20 minutes as their presentation, and then we will have questions. We will start first with Mindy, and then Sarah, and then Kristen. So at this time, I'm going to turn it over to Mindy Weinstein.
Is this on now? Okay. Wow. I sound really, really old. I'm going to cut my bio. Thank you for including me here tonight. The EEOC is very happy to co-sponsor this event and be part of providing information and to this community. So thank you for including us. Of course, at the time that I was initially invited several months ago by Antonio, it seemed like a really good idea at the time to come out to Arlington in July, and we could sit outside and have drinks after the event. And now I need a rowboat to get home. So I'm a little concerned about this, but Antonio says he can't control the weather, but I don't know. So anyway, I'm happy to be here and talk about what EEOC does, the Equal Employment Opportunity Commission, and how the laws that we enforce apply to people who are immigrants here in Arlington. So let me go ahead and get started. Oh, this is interesting. Okay. First of all, what is national origin? And I have teenagers, so all the teenagers in the crowd, you guys have to pay special attention or else I'm going to call on you, okay? What does anybody know what is national origin? When we say it's illegal for employers to discriminate based on national origin, does anyone know what that means? You have a guess? You have a guess? Go ahead. You can explain it from what you see. Okay, individual born somewhere else outside of the U.S. Would it apply to people born in the U.S.? Good. You get a star. Okay, so it basically covers people who are being treated differently because they are from a certain place, like a country. It could be Mexico, El Salvador, China, any country or a region in the world, or because they belong to a particular group that maybe isn't just one country, like because they're Hispanic or because they're Arab or, some sort of group like that. So those, when it's a group like that, it usually means people who might have a common language, a common culture, they're from a particular place, or their ancestors are from that place, okay? So even if a person is born here in the US, if you're treated differently because of where your ancestors are from, your parents are from, or grandparents, then that could be also national origin. Now, our laws also cover people who are treated differently, even though they are not from a particular national origin, but because other people think they are. Okay, so the perception that they're from a particular place is also covered, and also if you're discriminated against because of your association with someone of a particular national origin, that would be covered. So if you're American-born, Caucasian, but your girlfriend is Hispanic, or this applies to race or other types of things that our laws cover too, then if you're being treated badly at work because of your girlfriend's national origin, then that would also be covered by our laws. Does that make sense? Okay. So when we say that it's illegal for an employer to discriminate based on national origin, first of all, we mean that it's illegal for an employer to treat two people differently, or any number of people differently, based on that national origin, okay? So let's say people come in and apply for a job, and the employer thinks, okay, I don't want to hire people of this national origin for this job. I want to hire this other person because they're American born, or they don't seem foreign or whatever. Then that would be illegal. So if you're treating people differently when you're hiring based on their national origin, that's covered by our law. But it applies to other things too, like paying people lower wages based on their national origin, subjecting them to different work rules based on their national origin, paying the people of a particular national origin a lower pay. All of these things unfortunately happen, and so our laws are out there to say that that's not okay. It also prohibits employers from sort of segregating people, putting people in particular jobs or giving them assignments according to what their national origin is. So it covers really everything that has to do with work. You can't treat people differently based on national origin. It also applies to situations where the employer isn't purposely saying, I want to pay that group, that national origin group differently, lower wages, or treat this group differently, but also where they might have something that seems neutral, like everyone has to have a college degree to work here, or everyone has to have lived in their current home for 5 years, or like you could have something that sounds sort of neutral, but if it has a disparate impact on a particular national origin group, then that could be unlawful too. Sometimes national origin cases overlap with other types of cases. So a person from a particular national origin might also be discriminated against based on their race or their religion. It could be based on their sex, like women of a particular national origin are treated worse than everybody else. Does that make sense? So it could be a combination of two different kinds. And also something to keep in mind is an employer can't say, well, we treated people differently, or we didn't hire that kind of person from that country or that kind of national origin because our customers wouldn't like it. Like, we're a Mexican restaurant, so we just want to hire Mexican people because it sort of fits in better, or we're a Chinese restaurant and we just want to hire Chinese people. Then that's not okay. Or you can't say, well, we just want to put white people in the front of the house at a hotel and other people in the back of the house jobs because that's what our image is. All of that is not okay. So I'm going to just give you real quick a couple of examples. The first one, Thomas is Egyptian. He says he was fired because of his national origin. He overheard his new manager say to a coworker that he looked like a Muslim terrorist. Could this be national origin discrimination? Yes. Could it be anything else? Religion. Right. So this is an example of where you might have both. Here's another situation where a Chinese American student applies to work at a clothing store. She's qualified. She's worked in this kind of retail sales jobs before, but she ends up getting an interview where she's asked, where were you born? And she's told she looks foreign, and they say that her appearance is not going to fit our all-American image. She's not hired. Would this be discrimination, do you think? Yeah, this is an actual case, kind of sad, against Abercrombie & Fitch, which some of you may have heard of. Okay, so we also covered discrimination involving harassment because of national origin, and a remark or two is not usually going to be enough, but if it is repeated or very severe, then it could be illegal to subject somebody just to remarks, even though you don't take an action like fire them or fail to hire them. And so it could be ethnic slurs, graffiti, offensive comments, that sort of thing. And employers generally have an obligation to try to avoid that by having good policies, by educating their employees about what their rules are, by having a procedure where somebody who hears that kind of remark or is treated that kind of way knows what to do. And then the company follows up properly if that happens. So here's a quick example of that, where a person is subjected to name calling, called spick and other words, and is embarrassed in front of customers, and that it's just constant. It happens all the time. So would that be harassment under our laws? Yeah. Okay. So now let me talk about a few special issues, starting with language issues. Obviously, language is often very associated with national origin. So that can come up in a few different ways. One is accent situations. So where a person might have an accent because they were born in another country and they learned English later, and so they talk like they're from another place. So can an employer harass someone based on that? No. Can an employer not hire someone based on their accent? Maybe. Probably not. But if the accent materially interferes with the person's ability to do their job, then the employer can say, you just can't do your job because, this is a job that requires a lot of communication with English-speaking people, and your accent is causing a situation where the people cannot understand what you're saying. If it's really a strong accent and you really need to be able to speak with clearly because it's a customer service job, for example, and the accent materially interferes with the person being able to do that, then in those limited circumstances, you could have discrimination. Okay, I'm going to talk next about fluency requirements, where an employer says you have to be able to speak English fluently. So the person can speak some English, but maybe isn't perfectly fluent. Is that okay? Well, it depends. An employer can have an English fluency requirement if the job really requires English fluency. So it has to be necessary for the position in order for them to have that policy. So let's say the company does like a test when everybody applies for a job to evaluate whether they're fluent in English. Again, only okay if the job really requires that. And lots of jobs don't, but some jobs do. What about English-only rules, where an employer says you can only speak English at work? Most of the time, that's not okay. Certainly, if it's a flat-out, you can never speak a language other than English, that's probably illegal. But if the job involves a lot of communication in front of customers and clients, and an employer might be able to say, well, speak the other language other than English, but on breaks and lunch and but if they flat out say you can't speak anything but English at all, then that is probably illegal. Citizenship issues, I think that Sarah's going to talk about, but there's sometimes a little bit of overlap. But we do not cover discrimination specifically based on citizenship. But we certainly, if people are of one national origin are treated differently than people of another national origin, then that would be illegal. And all our laws apply regardless of anybody's work status. So we don't ask, we don't, inquire about that at all. Here's we have a ton of information on the EEOC's website, which is eeoc.gov, and you can certainly check that out. And much of it is available in Spanish and other languages as well. So what do you do if you think you've been discriminated against and this kind of thing has happened to you at work? So you can file a charge with the EEOC. We cover the federal law. We're sort of partners with Arlington, which covers similar rules, but I'm going to just briefly cover what our rules are. You can file a charge. For us, you have to normally file within 300 days. If you work for certain entities like Metro or the entity that provides services at the airports at Dulles and National, those folks are not covered by Arlington or any other state or local agency. So for them, it's 180 days. For every other employer, you have 300 days to file. And not every employer is covered by federal law. Generally, you have to have at least 15 employees in order to be covered. Once a person files a charge with us, we send a notice, usually by email now, and that's normally sent within 10 days. The charge, when we get the charge, we would normally, if it was filed against an employer in Arlington, we would send a copy of it to the Arlington agency. We have a mediation program where if you file a charge, in most cases, we'll invite you to participate in mediation. That's where the two sides in the case get together and there's a neutral, a trained mediator who tries to get everybody to be able to talk about the situation and see if they can resolve it. It's free, it's voluntary, nobody has to participate, but it's super successful if both parties do. About 75% of the time the case is resolved in mediation. It's very fast. It's like right at the beginning. If the case does not go through our mediation program, then we normally send it to our investigators. We have about 10 investigators in my office. The investigation may involve all different kinds of things, normally talking to witnesses, other people who worked there, talking to the person, of course, who filed the charge, talking to the employer, getting what their take is, what they say is the reason that they took the actions that they did. We might go on site and talk to some of the managers. We might bring the parties together in a conference where both sides, like the key people, might tell their story, and we try to help each other understand the different views and for us to be able to gather evidence as a result of all that. So ultimately, this leads to a settlement, which might happen right away through our mediation program or later during the course of the investigation. If we don't think there was a violation, then we would issue a right to sue notice and the person can go to court. They have 90 days to do that if they decide to do it. And if we think there was a violation based on the investigation that we do, then we issue what's called a reasonable cause finding. And then we say to the parties, all right, we think there was a violation. We'd like to try to help you resolve it. We again try to settle it. If we can't settle it, then the case will be considered by our legal department and we may file a lawsuit. And real quick, there are remedies available under these laws. If the person wasn't hired or they were fired and they lost actual pay or they were paid lower wages based on their national origin, then a key part of the remedy is getting the pay that they lost. There might be other monetary payments that could be available as well. There's maximum caps on those depending on how big the company is, ranging from $50,000 for smaller companies to $300,000 for bigger ones. And then we look for a lot of types of relief beyond money that can try to solve the problem and also make it so that it's unlikely that that kind of discrimination would happen again. So it could be mandatory training for the managers, new policies, new procedures, that sort of thing. That's just what our website is, if I said it too fast. And I guess I'm going to turn it over now, and I'm happy to answer questions at the end as well.
Sarah?
Can we hear me? Fantastic. All right. Well, my office also very much appreciates the opportunity to be here this evening. Thank you so much. I work for the Immigrant and Employee Rights section. We're part of the Civil Rights Division in the United States Department of Justice. So we're located in DC. We're only located in DC. We're a smallish office of about 30 to 35 people, most of whom work on enforcement work, which I'll talk about here in a moment. In a nutshell, what IER does is investigate and sue employers who violate the who violate the anti-discrimination provision of the Immigration and Nationality Act, which is just a lot of words, but I'll illustrate that a little as we go here. Thank you so much. That law that I mentioned that we enforce, it prohibits employment discrimination based on one's citizenship status and national origin. And our law protects work authorized folks. So one's legal right to work in the United States is relevant to the protections that we offer. It's just how the law is written. So our office, we like to think about our office, the scope of our work in 3 pieces. Enforcement is the largest piece. As I mentioned, we're about 30 or 35 people downtown DC. It's civil rights attorneys, investigators, paralegals, hotline staff, and myself. As we talk more about the law, you'll understand more about the enforcement aspect. We do policy work with sister agencies to promote our shared missions. We have a partnership with the EEOC that's very valuable. We do a lot of work closely with them, as well as other federal, local agencies, even some foreign governments we have partnerships with to further our shared mission to protect workers from employment discrimination. And outreach. Lucky for me, we have an outreach mandate, and I'm the outreach coordinator. We love to do in person to get out and meet folks in the community where we can. But we also do monthly webinars live that are conducted by our attorneys, our investigators, myself. So I encourage you, if you're at all interested in what I'm talking about, to sign up for one of those on our website, because this is going to be 20 minutes, whereas our webinars are an hour long, and they go much more into detail about the things I'll just touch on lightly today. And another important part, what's the purpose of our outreach? It's to inform employers about their responsibilities under our law and to educate workers about their rights under our law, their protections. So it's all the same material, just at different audiences. I wanted to mention that we offer a webinar in Spanish every other month, and our office is really big on language access, so we have a lot of materials in a number of languages, as the EEOC does as well. The hotline that we answer that I'll talk about, we're all bilingual Spanish, English, and we have, of course, language lines, so we seek to be very inclusive for folks who may need languages besides English. So let's just look here. These are the 4 things we're going to touch on. These are the 4 prohibited actions for employers under the law that we enforce. So citizenship status and immigration status are used interchangeably when we talk about our law. National origin discrimination, unfair documentary practices, and retaliation. Those are all protections we offer to workers. And the unfair documentary practices one is the most common infraction that we see, and it's also the one that most people don't know is illegal. So I will talk about that here in a bit. Okay, so discrimination, citizenship status discrimination in hiring and firing decisions is illegal under our law. This can happen in our law when an employer refuses to hire someone or fires someone based on their citizenship status. And so I'll talk about who's protected and what the exceptions are to this law. This is kind of one of the more subtle areas of the law that we enforce. So those who are protected from this kind of discrimination are U.S. citizens, U.S. nationals, recent lawful permanent residents, refugees, and asylees. And what they have in common is that they have indefinite work permission. So just for this particular part of the law, those are the protected individuals. And the exceptions where an employer would be allowed to make hiring decisions based on citizenship status would be where there's a law, regulation, executive order, or government contract that requires the job to be, the position to be limited to certain statuses. But in the absence of that, an employer is not allowed to make their hiring and firing decisions on a whim or because of a personal preference. And this, for our law, applies to employers who have 4 employees and up, so most employers. So as I go through, I'm just going to mention some of the recent settlements we've had related to the kind of, the part of the law that I'm talking about. So in January of this year, we settled with Omnicare, which is a subsidiary of CVS out of Ohio. Our department's investigation found that Omnicare engaged in citizenship status discrimination in hiring when they refused to consider an asylee for their candidate pool, just because they were an asylee. And Omnicare didn't have any legal base to do that. So we found, we settled, they paid a civil penalty of about $3,600 to the US government. And as Ms. Weinstein was saying, not only do civil penalties and back pay, not only are those what we typically seek in our settlements, but also injunctive relief. So there's almost always training of the company, monitoring and compliance. So that was that one. And because Ms. Weinstein did such a masterful job talking about national origin, this is going to be an easy job for me, so thank you. I'll cut down a lot what I was going to say, fantastic. So it's really helpful to have had Ms. Weinstein speak first about national origin because it's easier to understand my office's work with national origin discrimination against the backdrop of the EEOC. Because what we do with national origin discrimination is not as broad, it is more narrow, still important. So for our law, employers may not make hiring or firing decisions based on your national origin. That also extends to recruitment or referral for a fee, which is also, it's like staffing agencies when they're involved. So whereas the EEOC has terms and conditions where you can't treat people differently, say in pay based on national origin, our law is limited to the hiring, firing, recruitment, or referral for a fee actions. And also, our law only has authority generally over employers who have between 4 and 14 employees. So it's narrow, but we do good work with it. So the settlement I wanted to highlight for this part of our law is from February of this year. In New York City, there's a restaurant called Ichiba Ramen, and they refused to hire an applicant because they weren't from a particular country or region of the world that the restaurant wanted as part of their image. So that the injured party happened to be a man who identified as Latino. He was a U.S. citizen. He got $1,700 in back pay. The company had to pay $2,000 in civil penalties, and they will probably never make that mistake again. Let's go to unfair documentary practices. All right, as I said, this is probably the most meaty. So when we do our full-length trainings, this is like, I have you take a deep breath, stretch before we get into this one because it's very involved. But lucky for you, we're going to do 3 slides on this, and I'm going to give you the most important points. Because what I really want to do here in this brief and lovely forum is to give you enough information about our law so that if something similar pops up in your life or the life of your loved ones, your community, your clients, you can say, ooh, I'm going to call IER, I'm going to talk to them about this, maybe this is something they can help with. If they can't help with it, I'm sure they'll tell me who can. So that's my goal in terms of the scope I'll expand to in this unfair documentary practices discussion. So unfair documentary practices refers to discrimination that can occur when an employer is getting proof of someone's legal right to work in the United States based on their citizenship status or national origin. So when they're treating someone differently in the Form I-9 or E-Verify processes based on their citizenship status or national origin. Form I-9 and E-Verify those are actually run by Department of Homeland Security, United States Citizenship and Immigration Services. So we don't govern them, but what we do is investigate discriminatory use of those procedures, which they're referred to as Employment Eligibility Verification, EEV, for those who are in the know. So when an employer treats someone differently, even if they didn't know it was illegal, which is typically the case, that the employer is breaking the law under the unfair documentary practices part of our law, they typically have no idea they're breaking the law. So it's not with malice, and we don't have to show malice in order to determine that an employer has broken our law. So this applies to employers who have 4 employees and above. So here we go. Does everyone kind of recall? I know when you start a new job, you're given a lot of paperwork and you kind of sign it all in and give it back to them. But the Form I-9 is the one that's used to verify identity and permission to work. And the really important thing that I stress for employers and workers is that its purpose is not to show someone's particular immigration status. And it might seem like a subtle difference, but the distinction is actually very, very important, because the difference between the two is that the latter, if you're trying to prove what someone's particular immigration status is, tends to put up unlawful barriers to employment. And that's the problem. So we also put up USCIS's I-9 Central website because it's such a wonderful resource for information about proper Form I-9 procedure, and also includes information about discrimination protections. So let me try to sum it up. No. Here we go. I probably pushed the wrong button. Okay, so unfair documentary practices and Form I-9 and E-Verify, an employer based on my citizenship status or my national origin cannot request more or different documentation than I chose to show. They can't reject reasonably genuine looking documents, and they can't specify certain documents that they would just like to see instead of the acceptable ones that I chose to show. So with the Form I-9, there's a list of acceptable documents, and there are 3 columns. And I'll just whiz through it because I know it's a little meticulous, it's a little tedious. But so if I started a new job and I'm filling out the Form I-9, I get to pick, no matter what my citizenship status is or my national origin, I get to pick if I choose something from column A or if I choose a combination of column B and column C. I could get into that, but really what I want to instill here today is that it's the worker's choice what they want to show from the list of acceptable documents to show their employer, 1, who they are, and 2, that they're legally authorized to work in the United States. And when the employer starts imposing different requirements on people in this process based on their citizenship status or national origin is when they can run into infractions of our law. So I'll just do a really, really quick quiz in which I will give the questions and the answers in the interest of time. But to illustrate a little bit, let's say I'm a lawful permanent resident, and I mark that on my Form I-9 because that is one thing that you happen to mark if you are on the Form I-9. And I go to work and I show them my Social Security card and my driver's license. Is it okay for my employer to say, no, I really need to see your permanent resident card because you're a lawful permanent resident, so I need to see that particular document. Would that be okay? No, good job. See, I don't have to give the answers, you know the answers, that's great. Okay, let's say I'm a US citizen and I speak with a foreign accent, like my own mother, actually. Let's say I start my new job, I show my US passport, here you go. Should be good to go because that's a list A document. But my employer says, oh, what a lovely accent you have. I'll need to see your naturalization certificate just to be sure you're a US citizen. Would that be okay? No, not in the least. Okay, one more. Let's say that I mark that I'm an alien authorized to work on my Form I-9, and that's an umbrella category. There are a ton of different citizenship statuses that fall within that. So I mark that. And I go to work and my employer says, oh, you're an alien authorized to work. Okay, I definitely need to see some immigration documentation from Department of Homeland Security to let you keep working here. How about that? It's a no. Nope, also not okay. Because based on the citizenship status, they asked me to see something specific, and we're trying to verify my immigration status, so my particular immigration status. Okay, the case that I would highlight for unfair documentary practices, a recent one from April of this year, is out of California, I think. ThemeSoft Incorporated. They actually violated the citizenship status discrimination part of our law and the unfair documentary practices part of our law because they refused to consider an asylee for employment because he's an asylee, and B, requested that he produce a specific document to prove his particular citizenship status. So they really should have read the rules, unfortunately, before they did that. So luckily, that person found his way to us, filed a charge, and because this is a staffing company, their civil penalty was $200,000. And when it's a staffing company, the civil penalties can become very high because of the amount of employees that they have. And then this individual got $12,000 in back pay, so that was nice. Oh, I'll just say I just put two cases together. City staff is the one I was just describing, not ThemeSoft. Scratch that. City staff. Okay. No? Yes. Okay, the fourth part of our law that protects workers is protection from retaliation. Our retaliation protections in our law are rather broad, so they include intimidation, coercion, threats, really any adverse action that an employer would take against anyone who raises, who asserts rights under our law. So whether you're asserting rights for yourself as a victim or for someone else, or if you at all engage with my office by calling the hotline or answering the phone when an investigator calls, or in any way cooperate in our investigations, and you suffer any adverse action from your employer, that could be then another infraction of the law by the employer. Okay. Our charge form we have available in 11 languages. You can file it completely online from our website. The website will be on the final slide. For us, you have to file the charge within 180 days of the alleged day of discrimination, the day that the discrimination allegedly took place. So that 180 days is really important. And a lot of times people don't jump right to filing a charge, but they'd rather call and speak with us about it. And our office is really, really accessible to the public. You can call our hotline. You can even ask anonymous questions in any language you want. And we answer in 1 to 2 minutes. It's pretty quick. I'm often the one answering. So, and I really enjoy it. I love hotline work because we get to share so much information with workers and employers that protects people's right to work. So there's that. And finally, here's our hotline number for workers. We're there faithfully Monday through Friday, 9 a.m. to 5 p.m. Eastern Time. Please note our URL there. Our website has a lot of information on it. And so I'll just mention about our worker hotline. We have an employer hotline too, but I just listed the worker one here. We really, all day, our staff is giving really useful information to workers and employers about the law that we enforce. And then when folks call the hotline and it's something that doesn't fall under our purview, we put a lot of effort and care into providing people with the relevant information that will get them where they need to be. I make so many referrals to the EEOC. I have the EEOC on speed dial. So we love our hotline. We think it's really useful for the public. So not only do we provide information on the hotline, though, we have an informal intervention program. So let's say one of these things that we referenced in the quiz were to happen in real life. one could call the hotline, say, hey, this happened to me, can you help me fix it? And depending on the situation, we're often able to say, sure, let me give your employer a call and see if I can just straighten it out informally. That's the fastest way to get you back to work. And so that's something that's really special and unique about our office. So I really like doing those interventions. Getting people back to work is very rewarding because no one wants to be without a paycheck unexpectedly. And then I'll just mention if there are any refugee or asylee service providers in the audience that apart from the interventions that we do that are under our purview, we also are able very informally and without authority to help folks who have problems at the DMV getting their license, maybe because the DMV isn't understanding their documentation, like their employment authorization document was auto-extended and they didn't understand it and they rejected it so the person can't get their driver's license. Those are things we often fix probably every day on the hotline. So that's all I wanted to cover. Thank you so much. I can turn it over to Christine. Thank you.
Thank you, Kristen. Kristen, thank you.
Hi, everyone. Good evening. My name is Kristen Donovan. I'm an attorney with Legal Aid Justice Center. Thank you all for coming. So I just wanted to briefly introduce Legal Aid Justice Center. We're a nonprofit that serves Virginia. We provide legal services to low-income Virginia residents. We've got offices around the state. One of them here in Falls Church focuses on providing services to the immigrant community. This is where our immigrant advocacy program is based. So we do all types of law. We do employment, housing issues, some immigration. We also do kind of impact cases around civil rights, immigrant rights. In terms of our employment work, we help workers, low-wage workers, recover wages that are owed to them. So it's often, overtime issues, minimum wage, or contract violations. I specifically have a fellowship to work at LAJC through the Gallagher Family Foundation, focusing on providing legal services to cleaning workers in Northern Virginia. So a big part of my fellowship focuses on helping cleaning workers with wage and hour issues, so recovering unpaid wages, and also helping cleaning workers who experience discrimination, sexual harassment in the workplace. So today I wanted to talk a little about the work that I do with cleaning workers in terms of harassment and discrimination, and then some of our wage and hour work, so helping workers recover unpaid wages. This is a little close. With the cleaning industry here in Northern Virginia, sexual harassment is a huge problem. I think cleaning workers are pretty vulnerable. A lot of them work late at night. They work in isolation. So a lot of the people I work with, a lot of them are immigrant women, and they work cleaning office buildings, cleaning homes, cleaning, malls. So a lot of the times, like let's say they're cleaning at night, there's no one there in the office building. And they're very isolated, so that makes them vulnerable. Also, a lot of cleaning workers don't have work authorization, so that's something that, bad bosses, the person who's harassing them can use against them to try to intimidate them, prevent them from speaking up, saying something, getting help. So we also see other forms. Sexual harassment is quite prevalent, but we also see other forms of discrimination, national origin, race, age, disability, comments in the racist comments in the workplace. We see employers trying to force out workers when they're a little older. Cleaning work is pretty demanding, but we do see, older workers who can do this work, who are employers try to force them out to hire younger workers. So just to give you an idea of some of the Title VII discrimination violations that we've seen in the cleaning industry. One of the ways is a hostile work environment. So that's when someone's, forced to endure kind of an abusive working situation. It might be that a supervisor is constantly making kind of crude sexual jokes, asking them out on dates, and then all the way down the line. So then, kissing, touching inappropriately in the workplace. And sometimes it often rises to a level of physical violence, assault. The abuser, oftentimes it's the supervisor, but it doesn't have to be, it could be a coworker. It could even be, a client. So if someone's cleaning an office building, someone who works in that office and harasses them. We also see retaliation. So, one of our clients, her supervisor was constantly asking her out, trying to touch her inappropriately at work. And when she rejects him, she's suddenly, given a more workload, a higher schedule, or a tougher schedule. So kind of actions that an employer might take to make your life more miserable. If you reject sexual advances, if you complain, if you complain internally or make a complaint to the EEOC. We also, obviously a lot of retaliation would be cleaning workers getting fired, for speaking up, for rejecting sexual advances. So what LAJC, we don't do, Legal Aid Justice Center, we don't do a lot of Title VII discrimination work generally, but with my fellowship, I can provide services to cleaning workers who experience harassment and discrimination in the workplace. And what we would do, first we might use more informal methods, write a letter, contact the employer, try to negotiate something. If that doesn't work, we can help someone prepare to file a charge with the EEOC or a local agency. If the EEOC does not end up resolving the situation, we could help the cleaning worker litigate, take the case to federal court. A few of the obstacles that we see sometimes with people that come in, the 300-day time that you have to file a complaint can be difficult for some people, might come in a year or two later. If you do miss the deadline for filing an EEOC charge, it doesn't mean you don't have there might be other legal claims that you have against an employer, maybe a civil assault, like a tort claim or negligent hiring. There's other things that you might be able to pursue. And also a lot of times, for understandable reasons, someone who's being harassed in the workplace might not tell another supervisor, a manager. It's important for people to, go to the next highest person, make a complaint, make sure that the company is aware of what's going on, use the complaint procedures if there are any that are established by the company. And now moving on to wage and hour issues. So that's a lot of the work that we do. There are, in Virginia, to give you just an overview of the laws, one of the main laws that protects workers is the Fair Labor Standards Act. So that guarantees a minimum wage, which is $7.25, pretty low, and overtime. So when you work more than 40 hours in a work week, you should receive, time and a half. Virginia also has a wage and hour law. It's pretty similar to the federal law. So we usually just use the federal law when that comes up. But if someone works in Maryland or DC, they have a higher minimum wage and they have stronger laws. You can recover triple the amount that you're owed. You can recover the wage that you were promised. So if someone works, let's say they work half the time in Virginia, half the time in Maryland. Cleaning workers often travel around the whole area cleaning houses. Then they might be able, for the time that they spend in DC or Maryland, might be entitled to a higher wage rate. One One important thing to know is that undocumented people are covered by these laws. The laws don't discriminate. Undocumented people have the right to go to court, right to get paid wages owed, overtime. So just to talk quickly about some of the common problems that we see. Obviously, there's the really obvious wage and hour issues. So a lot of times people come in and they're just, an employer withheld a week of work, a month of work. They're just weren't paid for a big chunk of time. A lot of times employers make up excuses like, oh, we don't, if you quit without giving notice, we withhold your last paycheck. We hear that a lot, and that's definitely not right. An employer can't withhold wages, even if you don't give notice and you quit. And then there's other wage and hour violations that are a little, maybe not as obvious, a little more subtle, that we see a lot. One problem that comes up in the cleaning industry, oftentimes cleaning workers are paid at a rate that's, something other than an hourly rate. So they might be paid $60 a day, $800 every 2 weeks. They might be paid a certain amount based on how many houses that they clean. So when there's kind of a payment arrangement like that, oftentimes it might lead to someone not getting paid the minimum wage or someone not getting overtime. For an example, oftentimes cleaning workers who clean houses are paid, $50 for this house, $70 for this house. It's fine to be paid, it's at a piece rate like that, so a set amount for the work that you do, for the houses that you clean. But if someone works more than 40 hours, they still need to get an extra overtime premium. An employer can't get around overtime laws by paying, per house, per week. Sometimes someone might get paid like a daily rate, $70, and they're cleaning a house or houses that end up being really dirty and they take a long time. So it's important at the end of the week to add up all the hours, divide it, make sure that you're getting an average of the minimum wage or your promised wage rate and overtime. Another way that workers aren't getting paid what they should, when they're not paid for all the time that they should be getting paid for. So some of the ways you see this, workers not getting paid for the time that they spend traveling from one work site to another work site. So I think a lot of people know that, the time you spend going from your house in the morning to work, you don't get paid for that. But once you get to your first work site, so let's say you have a house, you're cleaning a house in Maryland in the morning, and then in the afternoon you drive to Virginia and clean another house. The time you spend traveling during the workday is compensable work time. So that's another way that workers are skimped on their wages. Sometimes a worker, you might be a cleaning worker might be required to start cleaning at 9 o'clock in the morning. But in order to start cleaning, they need 15 minutes to set up the work card, get the materials. All that time preparing to work is work time. Time that you have to spend waiting for an employer is also compensable work time. So let's say your employer makes you arrive at work at 10 o'clock in the morning, and then you have to wait for them for half an hour because they're getting you work materials. That's not time that you can just spend doing whatever you want. It's work time. Another thing we see a lot is deductions from pay, unlawful deductions from pay. So that might be employers taking out the cost of a uniform, tools, whether they deduct it from your paycheck or make you pay for it, it's the same thing really. So anything that's for the benefit of the employer shouldn't be deducted if it cuts into overtime or minimum wage. Even if it doesn't cut into minimum wage or overtime, it might violate a contract, your contract with your employer. And that happens a lot, especially in cleaning. We also see employers in the cleaning industry deducting money for damage to a house. And a lot of times people think, okay, yeah, I scratched that. You can take it on my paycheck. But an employer should not be deducting damage to a client's house from an employer. It shouldn't be the burden of the worker to pay for that. One thing we see a lot is that employers might not know that they're protected by some of these laws because their employers told them that they're independent contractors. The important thing to know is that the label doesn't really matter. The Fair Labor Standards Act, which guarantees overtime and minimum wage, has a very broad definition of who's an employer and who's an employee. So sometimes people might not think they're entitled to some of these labor protections when in fact they are an employee. They just have been called an independent contractor by their employer. Contract violations is another very common. So someone, they might be promised $10 an hour. They're probably not going to have a minimum wage violation. But if their employer pays them $9 an hour, then they've got a contract violation. Verbal or oral contracts are enforceable in Virginia, so you can still recover the wages that you were promised even if you don't have anything written down. Another important thing to know is that someone cannot contract away their rights. So you can't sign a contract saying, if I leave without giving notice, I forgo my last week's paycheck. You can't agree to not get paid. So we have seen some contracts like that, and they are a violation of minimum wage laws. As I said before, undocumented workers are protected by these laws. A lot of our clients don't have papers, but it doesn't mean that they are not entitled to what they're promised under contract, minimum wage, overtime. In terms of how our organization can help, a lot of people come in, and the first step might be, informal letter to an employer, informal negotiations trying to get a worker the money that they're owed. We file lawsuits in state court and federal court, and also work with workers to collect on judgments. So that's what we do. I'd be happy to take any questions.
Thank you, Kristen. At this time, we're going to open up for questions that people may have. Yes.
Yeah, I have a question for Mindy and Sarah. So basically, when it comes to contracts, most employers specify that for termination, they're not obliged to give the reason for termination when they decide to terminate an employee. So my question is, what are the tools available to employees in order to prove that there was a case of discrimination against them for any of the reasons that you provided, in order to kind of show that they were discriminated against in the hiring process, and at the same time, when they are being hired, what are the tools at their disposal in order to prove that during the hiring process there was an obvious case of discrimination when the employer can deny it, because again they can claim that they did it for a purpose.
I'll take a first shot. Okay, so basically, every once in a while there's a case where there's evidence that's really useful in proving that, like a person isn't hired and there is a person who worked at the company who overheard the manager say, I'm not hiring anybody in a wheelchair, or I'm not hiring a person who wears a turban, or I'm not hiring a Hispanic person, I'm sick of hiring them. Okay, so every once in a while you have that kind of evidence, but it's unusual. So the more common scenario is that you come forward and you say, I am, a person who wears a turban for religious reasons, or a person with a disability, or Hispanic, or Chinese, or whatever, and I think I was not hired, or I was discharged, or whatever, based on this kind of, for this reason. And essentially, if you show that you are a member of that group, and you were subjected to something like not being hired, or being fired, or paid certain wages, or whatever, and that other people were treated differently who are not in your group, then you've done enough to sort of create an inference, like a suggestion that it could be based on your race or sex or national origin or whatever. Then it is the employer's obligation to come forth and say, hey, this is the reason we did this. We didn't hire that person not because of their national origin, but because they weren't as qualified as the person we selected, or we fired them because of their attendance or their low sales or whatever the reason is. And then the question is the reason that the employer gave true? And so we look for evidence to evaluate that question. What were the person's sales? Were they the lowest sales? Was the attendance the worst? Did they not have the right kind of experience? So those are the kinds of things that we are typically looking for to evaluate if a person's done enough to give us some inference of discrimination. What does the evidence show about whether the reason the employer gave is true? Does that make sense?
Jessica, you had a question.
Hang on, I'm going to bring you a mic.
Okay. Hi, I'm Jess, Commissioner. First of all, I appreciate you coming. It means a lot to us. We're very excited to have you. So I have two questions. One of them is for all of you. So I've had friends, acquaintances say something along the lines of, I think I'm being harassed or discriminated against at work, but it's a right to work state. I have no recourse. There's nothing I can do about this discrimination. What would I tell those people?
That's not true.
It's usually along the lines of that I don't really know how to articulate to them that they still have a case when they're being discriminated against or harassed.
Yes. Our laws apply regardless of those kinds of things. Just as I just explained, if an employer takes an action against somebody based on their race, sex, national origin, color, disability, all the things we cover, then, and you can establish that, then that is a violation of the law.
Got it, okay.
Same here. If I would say maybe on the hotline, I'd explain it like even though it's a right to work state, that doesn't give the employer license to break the federal law that we enforce.
Right.
Okay.
So it's about doing your best work to identify the law that's potentially been broken and then going from there with that agency.
Got it, okay. And then my second question is mostly for Kristen. So if we have somebody, let's say they're working for an employer based in Virginia, but they're doing work in DC and Maryland during the day, is their minimum hourly wage based on the state they're doing work in or based on the state that their employer is based in?
It should be based on the state they're doing work in. Like they're working for an employer based in Virginia.
Yes.
And doing work in DC and Maryland. Yeah, they would be, since they're doing work in DC and Maryland, I think they would be covered by their laws.
Got it, okay. Thank you.
I have a question about, I guess, how to handle the situation. So I'm a government contractor for the federal government, and some of the situations that I've seen are sort of sexual harassment in the workplace, but more so on the customer side. So a federal employee, usually in a position of power, is harassing or showing inappropriate affection for contractor staff. And oftentimes, it'll get reported through our company's HR, who is hesitant to do anything because if you bring it up to the federal government, then oftentimes they look at you as sort of a troublemaker company who is creating problems for them because now they have to take action based on what you did, and that it can adversely impact your company's reputation and your ability to keep that contract or win future work within the same space. What in your recommendation is the best way to deal with situations like that?
So we see this a lot, and we have an entire guidance on this topic on our website. And if you go to our website and you type in the word contingent workers, that guidance will pop up. But the short answer is that a contractor such as your company does have an obligation to try to provide a work situation for its employees that is free of discrimination. So the basics are that the company would need to go to the government and say, hey, I'm concerned. My employee has raised this. I want to share this with you. It doesn't have to be threatening or, combative, but it does need to say, we're concerned. We'd like to investigate this. We want to talk to, so-and-so employee or some of the coworkers. This matter has been brought to our attention. You could even say under this, I read up on this on the EEOC's website, and it seems like we could both get in trouble if we don't do something about it. Because in our view, that person who works for your private company can also file a complaint with the federal agency, even though they don't directly work for the federal agency, because in that situation, both are sort of controlling the work situation for that person. So the federal agency should take action, because they could be held responsible for harassment too. And I spend a lot of time talking about sexual harassment, and no one really believes me, but I really think that the main message that employers need to understand is that when someone brings forth a harassment claim, instead of thinking, oh my God, take it away, that's terrible, I don't want to know, the real response needs to be thank you. Thank you for bringing this to my attention, because if an employer is liable if it doesn't do the right thing once it knows, in most cases. I mean, it also has to put in good prevention and all that, but if an employee brings something to their attention and they don't take action, or they should have known that it was going on, then they're much more likely to get in trouble for it under the law. So, you know, I'll do my part in trying to educate federal agencies and others that it's a good thing. If there's a problem, it's a good thing to know about it so you can fix it.
Thank you.
I'm usually pretty loud. I have a question. This might be more for Kristen, but if anyone has the answer, it'd be awesome. I work with childcare licensing, so like family day homes, childcare facilities, and a lot of our family day homes, they have assistants, and I'm fairly confident, but I don't get into that because it's not my job, that a lot of them may not be here legally. And my concern is one assistant had mentioned to me during a different investigation that really had nothing to do with her, but just some of the business practices of that provider, that if she had cooperated with our office, that she would up her background checks, and in some way that would flag her for being removed from the US. I don't know how true that is. I don't know if you guys have come across that or heard that. I don't want to ask her too many questions because I don't want to get into the whole not legal thing, but I'm not quite sure how to help her with this situation.
She's concerned if she does a background check, it might.
Well, she's already had one background check, just because all staff assistants are all required to have a background check. But she's worried that her employer is saying that she'll, like I said, I don't know if this is really true.
Target her, basically.
Yeah,
So they'll try to get her deported,
doing
threatening
more,
that.
Exactly, yeah. It's like she'll do more consistent background checks on her. She'll do other checks on her because she's being cooperative and she's helping us with the investigation. So I'm not quite sure how to talk to her about it, and because, you know, I work for the county, I don't want to ask her too many questions because I don't want to pull up a whole nother sheet of problems.
She could contact us directly and give us, we could talk to her
Okay.
confidentially about it, and she could give us, all the information.
Okay. I mean, have you guys come across that at all? Do you know if that?
Well, I think we have. I think there's been recently a local law passed about background checks and daycare.
Yeah.
So we have had some questions. I haven't handled them, so I'm not sure what we told people, but
Okay.
People have come to the office about it. I think kind of a little nervous. So she should just contact us directly.
Okay.
And we can talk to her about it.
Go through there.
Mm-hmm.
All right. I'll do that. Thank you.
Thank you.
Thank you so much for coming. Two quick questions. The first, this one's directed to Mindy. Can you guys hear me? What are the biggest pitfalls you see in effective anti-harassment programs, and to what extent, if any, would you recommend someone putting one together? Not really rely, but look to the guidance put out by the DOJ's fraud section last February in terms of effective corporate compliance programs. And then the second is, what recourse, if any, do volunteers or students have working at agencies or companies that are not employees and could not possibly be construed as such, even if you did the employee versus intern test? They come out clearly as interns or volunteers. What recourse, if any, would they have if they're being harassed in any way, whether sexual or not? Thank you in advance.
So the EEOC had a task force that looked at harassment, and about a year before the whole issue of sexual harassment exploded in the media, and it's, become a huge topic of conversation in the country. And so that was good because we were sort of prepared at that moment to be able to articulate a lot of the stuff that came out of this study. And a lot of it, the whole study is on our website, and there are 4 checklists for employers that are attached to the study, and employers should look at them. And one of them is on the kind of training that employers should do, and one of them is on the kind of anti-harassment policies that employers should have, and one is on procedures that they should have in place, and the last one is on risk factors, things that make it more likely that there might be harassment of any kind, including isolated workplaces is one, or youth employees is another. So I would strongly suggest that any employer look at those. They're amazingly useful. They're literally checklists. So it talks about what the kinds of elements that should be in a harassment policy at an employer and in a procedure, like how it should be treated confidentially to the extent possible, that there should be provisions there about how to report, that it should be provided in the languages that the people in the particular employment place speak, that there should be training on it, that there should be alternate ways to report, that there's a whole long list. And I think personally it's super helpful, and I'm sort of grateful that they got it all done, not anticipating that it would be such a huge topic, but it's got a lot of useful ideas for what should be in a harassment policy and procedure and training. The second question is much harder. I think that, you said the person is definitely not an employee. It's still something to look at. If there are some sorts of benefits provided, like metro subsidies or gym membership, okay, so I'm just saying, for the rest of the people who are willing to move off the possibility, there still might be some way that the person is covered. Yeah, you made the hypo, okay. I think that there are, the only thing I can really say is if the person is doing it through their school, there might be methods in that direction to pursue. And then there's always the power of persuasion. So the school or the individual or their lawyer or other organizations that help people, including possibly the Time's Up folks or others who provide lawyers, might be able to affect change, even though there isn't a specific law that would cover it. But I think the education angle might be possible.
Yeah, I would like to add that probably Title IX education might be something that could provide some help through the Department of Education.
Yeah, exactly.
Civil Rights
the
Office.
Education piece, yeah.
Kyle.
I would like to I encourage the moderator one more, and then,
Okay.
because it's getting late.
This is really more of a comment, not a question. I'm a small business owner, also a Human Rights Commission commissioner. Thank you for being here and educating us as commissioners as well as the community. As a small business owner, I appreciate the deterrent with regards to the penalties that employers have for discriminating against, but there's also an indirect cost for legal fees and the cost of the image of the company. I'm a small business that supports federal government contracting as well. And it's very important as a supervisor that everyone is educated with some of the harassment training that's available for free from these services that they provide here, to have every employee look at that if you don't pay for your own type of service in your handbook and policies that you have at your own employment. But it's really, really important. And the gentleman speaking, working in a federal workplace, the term blacklisting a company because of policies that they don't enforce, anti-discrimination, is very important. So thank you for your service.
Thank you.
Thank you. I think we're going to close at this time, but if anyone has any questions that they want to have of the panelists, please just come up at the end and direct your question to them.
I have a couple of comments to make. We had a group of students here from the Bugata organization. They had to leave early due to the weather and because they were expected home. They came here to gather information on behalf of their parents, which is very commendable. And they had a couple of questions of their own. I'm just going to throw them out there so that when they contact you guys, you know what they're expecting. Some of them were dreamers, some of them were not. Dreamers were concerned about what's going to happen to me if this situation does not change any further. I'm employed. My documentation is very limited. They had a question for Christine. They're being charged for the t-shirt that they wear in their place of work. And when that discount is made, they end up being below the minimum wage of Virginia. So thank you very much for the audience, and thank you very much for the presenters. The commission has something here for them.
Yeah, just one last thing. We also have for our panelists certificates of appreciation, and the certificate says it's by Arlington County Government. It's a certificate of appreciation. This certificate is awarded to in appreciation for your participation in a panel on employment rights of immigrants and non-citizens sponsored by the Arlington County Human Rights Commission, and it's signed by the chair, and also we're pleased to give with you Human Rights Commission pens as well. So again, thank you to our panelists for coming.
Thank you.
Good night and thank you, everyone.
Thank you.